Varun? Oh, okay, I'll call.
Yeah.
Can you make me a co-host, please? I'm calling you, just take the call once.
Hi, Supriya. Hello, Kirtana. Hello, Sumit. Dhananjay Chandrasekhar. Hi.
How are you doing, sir?
Good, thank you.
Heard you've been incredibly busy the last few months.
Yeah, the last few months have been a little busy.
Thank you so much for making it.
Pleasure. We launched, yesterday we had a very important meet of the E-Committee where we launched our e-filing 3.0. And we have just launched a free text judgment search facility on the National Judicial Data Grid.
Oh, that's fantastic.
People who don't, young lawyers who don't want to, so they can't afford to buy proprietary software, and even otherwise. I mean, for the media, for civil society, we have developed our own free text search engine for judgments. So I spoke about the new initiatives, and I told everybody about the fact that we've got the draft vision document for phase 3.
Yeah.
Opened it up now for public comments and suggestions. I got your email as well on that, and
yeah, it's been doing well. I think the response has been really good so far.
Wonderful.
So we're having a few town halls.
Yes, Supriya, we have put it out on My Government, the My Government platform of the Government of India, so that we can get the maximum of public comments.
Yeah.
And apart from that, I've requested several of the national law schools, Delhi, Bangalore, Hyderabad, Kolkata, and Jindal in Delhi again to give us their feedback. I've also written just this morning to Mr. Amitabh Kant. Good morning, sir.
How are you, sir?
All well. I've just written a missive to you this morning. We have prepared the a vision document for phase 3 of the e-courts project.
I know.
Agami, Daksh, and Vidhi were very closely working on it, and they've invited broad stakeholder participation. So I've just written to you enclosing the document and requesting you to have a look at it and give us whatever suggestions you want for
we'll be delighted to do that, and we'll get
back. It'll be wonderful because we are now looking at it for the next 3 to 5 year term. So it'll be wonderful if we get some feedback from you on that.
No, we'll be delighted, and we'll work on it and get back to you very early.
Wonderful, that'll be great.
Yeah. So with your permission, can we start?
Absolutely, all set.
Sure.
Varun, we're good to go.
We're good to go.
Fantastic. Okay. Good morning, everybody. Welcome to all those of you both in the room and listening to us live. We're all really delighted to be here this Saturday morning. To quickly introduce myself, I'm Supriya Shankaran, one of the co-founders of Agami, which has been working actively over the last 2 years with a range of actors, startups, businesses, civil society organizations, government and researchers to build the ODR ecosystem in India. Last year, and more particularly even the last few weeks with the second wave of COVID, has reiterated the need for a accessible, trusted, and a speedy way for all of us to be able to resolve our disputes. And as one step towards that, we're all really delighted to have you here today to launch the Odr Handbook. This Odr Handbook that you will get a glimpse of through the day was co-created by Agami with Media Network, Niti Aayog, ICICI Bank, Ashoka Innovators for the Public, Trilegal, Dalberg, Dwara, and NIPFP. The design was by Cracker and Rush, and this handbook, more than anything, is an invitation and a tool for businesses to adopt ODR. And we'd like to play now a short video for you to give you a teaser into what you can expect from the handbook.
Imagine a world where disputes are handled quickly and efficiently with compassion and trust. Where dispute resolution is accessible to all, no matter where you are, regardless of your proximity to a court. Online dispute resolution, or ODR, makes that possible. The future of its kind ODR Handbook for your business. Niti Aayog, in association with Agami and Omidyar Network India, along with the support of Ashoka, ICICI Bank, Trilegal, Dalberg, Dwara Research, and NIPFP have come together to bring you everything you need to evolve how your business handles its disputes. Flip through the handbook to discover why ODR is the need of the hour and how it generates economic gains. Read on to understand what some of the truths and myths around ODR are, as well as what the experts say about the common questions that people have. In the next section, discover how ODR delivers results and meet startups who can help you implement ODR for your business today. Reading through the handbook will also help you understand who ODR works for well and the sectors implementing ODR right now. And finally, a simple action roadmap will get you up and started with ODR immediately.
Facilitating access to justice and ease of doing business by making dispute resolution cheaper, quicker, and most importantly, equally credible as conventional methods of dispute resolution.
I think there has to be a fundamental change in the mindset. We must look upon dispute resolution not as relatable to a place, namely a court, the traditional physical court, where justice is administered, and I use the word administered into inverted commas, but as a service which is availed of.
The future will be a hybrid model that combines the best of both worlds, and therefore we will have to reimagine the whole process of justice delivery to work in a hybrid system.
The ODR Handbook is free and available online today. To get your copy, visit disputeresolution.online now. Imagine a
So with that quick introduction into what the ODR toolkit and the handbook is, I would like to take the opportunity to now invite Mr. Amitabh Kant, the CEO of Niti Aayog, to provide a quick welcome note to all of us. As most of you know, Mr. Kant has been a key driver of ODR in India with unwavering support for access to justice through the synergies derived from law and technology and policy. Over to you, Mr. Kant.
Good afternoon, everyone, and thank you for joining us at the launch of the Handbook for Online Dispute Resolution. I would like to start by welcoming Honorable Justice D.Y. Chandrachud. Justice Chandrachud, who leads the e-court initiative, has on several occasions positively spoken about ODR and how it could be a very vital cog in combating the clogging of courts. Under his leadership, critical changes are already noticeable, such as introducing of e-filing from anywhere in India, making it available 24/7. And this, to my mind, is nothing short of a game changer. A quote from one of his addresses that has always resonated with me over the last year, and I quote, that we must look upon justicing not just as a sovereign function, but in the world of technology as a service which is provided to the community, unquote. I'm truly delighted that he's here to support online dispute resolution and the role of technology in justice delivery. In fact, I would go as far as to say that his encouragement throughout this entire process has led to unprecedented progress being made in online dispute resolution for India and technology for access to justice at a historically rapid pace. The ODR Handbook, which we launched today, is the outcome of a collaborative work done by several of the contributors to this exercise and a very diverse stakeholder base. We have Agami, we have Omidyar Network India, Trilegal, ICICI Bank, Ashoka Foundation, Dwara, NIFPEF, Dalberg, SEBI, RBI, everyone is involved in this exercise. And it truly reflects the importance, need, and success of collaboration and partnership around policies for justice delivery in India. This handbook intends to help facilitate the process to adopt ODR in India and to highlight an actionable process for businesses that wish to adopt ODR. I'm also grateful to the support given to this handbook by both Reserve Bank of India and SEBI, and their valuable contributions have been incorporated in this document. As we know, online dispute resolution is a very fast evolving dispute resolution mechanism that uses technology not just to aid, but to proactively assess efficient and affordable justice delivery. Many of you are aware that Niti Aayog established a committee chaired by Justice retired A.K. Sikri to formulate an action plan for ODR in India. Members of the committee included several secretaries to the Government of India. The report is at its final stages. Our hope with the report and subsequent action plan is that not only it will enable ODR in a sustainable framework, but one that adopts and endures the test of time for it to become an option of first recourse for several categories of claims in a dynamic fashion. This handbook will aid the process and serve as an initiative that is part of Niti's overall plan of generating awareness, encouraging capacity, and fostering an ecosystem brimming with capacity and capability. One of the most encouraging developments recently is just how progressive and in fact innovative the Supreme Court of India has been in adopting technology. Indian courts today are quickly adopting leading practices in a sustainable and forward-thinking manner. And I'm confident that we are witnessing a visionary period in the history of Indian court system. Online dispute resolution in India is at a pivotal cusp. A collaborative mechanism provides this potential to resolve a substantial percentage of disputes at the site of their occurrence without burdening the courts. Progressive and disruptive changes in justice delivery are critical components now that can alter the course of access to justice in an unprecedented way. No one has championed this cause with more eloquence and emphasis than Justice Chandrachud himself. A case in point is the recently released draft vision document by the E-Courts Committee chaired by him. It is Niti's privilege to have an opportunity to contribute to the access to justice movement through the interplays of technology and law with policy. And we are available at the committee's convenience to assist in any manner that we can and in any manner that Justice Chandrachud deems fit. I now take this opportunity to invite Justice Chandrachud to grace us with his inaugural address.
Thank you very much, Mr. Amitabh Kant. It's truly a great honor for me to be here. And at the outset, I thank you for the offer which Niti Aayog has made to be associated with the vision document for phase 3 of the E-Courts project. I've just written to Mr. Amitabh Kant this morning requesting Niti Aayog to give us their expert advice and suggestions and comments and their vision and their experience into fine-tuning our document for phase 3. Having said this, I must thank the organizers for inviting me to be a part of this launch of a unique handbook, which seeks to invite us to all reconsider our preconceived biases against the full-fledged adoption of ODR, or online dispute resolution. I commend all the organizations and individuals who have been involved in drafting this handbook, and I'm certain that this will become a watershed document in revolutionizing dispute resolution in India. I must begin my remarks this morning by acknowledging that the use of virtual mechanisms to more effectively resolve disputes is a topic particularly important to me, since I also serve as the chair of the E-Committee of the Supreme Court of India. Last year, the sudden onset of the COVID-19 pandemic transformed all our lives in unimaginable ways, which inevitably included the way courts operated. With necessary lockdowns in place, the physical hearings had to give way to virtual hearings. This transition was difficult for everyone, for me and my fellow colleague judges, the advocates, litigants, and even all the court staff. However, while this process was initially slow, the concept of virtual hearings eventually came to find its place in our judicial ecosystem. Admittedly, even today, there is resistance to conducting court proceedings entirely virtually. While many have acknowledged its need during the peak of the pandemic, they have always been quick to request a move back to physical hearings, as and when the pandemic seems to have subsided. However, I'm not here today to discuss the merits of virtual courts. Rather, I wish to use our lessons from the past year to highlight why ODR is in fact the need of the hour. The ODR Handbook, interestingly, compares the use of ODR to that of another innovation, the automatic teller machines, the ATMs, which many individuals assumed would lead to the erosion of the position of a friendly bank clerk, the friendly bank teller. Since this happened in 1967, I think we can all safely say that the fear of ATMs was rather unfounded. On the contrary, that very fear has often been easily explained by behavioral economists in terms of a status quo bias, which is a preference for things as they are in the present. Since this bias can often be subconscious, it falls on each of us strongly to introspect what exactly is stopping us from adopting newer solutions, such as ODR. The ODR Handbook does an excellent job of helping us by identifying three things. First, the problem with our status quo. Second, how ODR can help fix it. And third, why is this the right thing to do at the right time? On the first count of the problem, the ODR Handbook notes that traditional litigation in India can be time-consuming, expensive, and onerous. As a representative of the judiciary, I do note that we are doing all that we can to remedy this ourselves. For example, we have made the pendency data of all cases before the high courts and district courts public on the National Judicial Data Grid in order to become more transparent about the problem. However, it would be rather remiss on our part also not to acknowledge that processes like ODR can definitely provide a helping hand. This can be done by limiting the kind of disputes that often come to courts in the first place. When alternative dispute resolution or ADR was first used as an alternative to the court systems, it was never meant to eradicate the role of the courts. In fact, therefore, I always called alternate dispute resolution as appropriate dispute resolution. Rather, its use was to reduce the burden on the courts and provide more efficient solutions for certain kinds of disputes, which would be better off being resolved outside of the traditional adversarial court system. I firmly believe that in today's digitally transformed world, a similar role can be played by ODR. On the second count of how ODR can help in fixing the problem, I firmly believe in its potential over and above traditional means of ADR. This is not just because of the process being conducted virtually, but also because of its firm willingness to adopt all forms of digital solutions available. In my opinion, one of the most important learnings from the past 1 year of virtual hearings has been that the process can often be far more efficient, and far more efficient because of very simple changes: the use of digital files by all parties, the ability to make digital notes, and having all documents in one place in ways that make them more accessible to everyone. These small changes, which improve the efficiency of the proceedings, lead to quicker resolution. Further, conducting all disputes online also helps generate a lot more data, which will provide the necessary groundwork for the process of ODR to improve in the future. In fact, this data can also be meaningfully used to improve the virtual experience of courts. Finally, the effective use of affordable ODR services can also bring about a major change in the perception of parties involved in the dispute. By making the process more accessible, more affordable, and more participative, it will make all parties consider it more amicable and solution-oriented. This will ultimately lead to more efficient dispute resolution. On the third count of this being the right time, the ODR Handbook recognizes three crucial factors. First, an exponential increase in digital penetration amongst all classes of people in the country. Two, the vocal support of the higher judiciary. And three, the steps taken by the RBI and by NPCI to incorporate ODR in areas such as digital payments. With a massive shift to virtual hearings in all courts due to the COVID-19 pandemic, questions regarding the efficacy of such a system are no longer theoretical. While there are always things to improve and issues to resolve, the system as it stands does work. The story with the ODR is similar, although crucially, organizations have been pushing for it and using it for far longer than virtual courts. Understandably, however, this push for ODR cannot mean substituting every dispute resolution process with ODR. That remains a distant and unreal possibility till we achieve digital penetration and literacy everywhere in India. However, I do not see this as a downside for ODR. On the other hand, I believe that its usefulness can in fact become a factor in pushing for stronger digital penetration and literacy. Even other than this, the Odr Handbook recognizes why ODR can be beneficial for the expansion of the economy, for the businesses looking for quick and efficient resolution, and even for individuals to whom traditional means of dispute resolution seem too onerous and inaccessible. It is my sincere hope that this ODR Handbook is shared widely and its contents become an important topic of discussion nationally on all platforms. It does not just do a good job of educating the members of the bar and the bench in the benefits of ODR, but it also correctly makes it seem friendly to business as well. Crucially, the success of ODR in India at such a nascent stage will definitely depend on whether business decides to adopt this as a means of effective resolution. To incentivize business, the handbook provides useful references to the success stories of ODR in other jurisdictions. It also assesses the kind of markets and the nature of disputes where ODR can be meaningfully integrated in the short term. Further, for those who are interested, the handbook also helpfully provides the details of organizations which are in the business of conducting ODR as of today. Simply put, the handbook seeks to function as a one-stop guide for ODR in India. To conclude my remarks today, I want to highlight that the pushback against ODR and virtual courts is often similar and even more often based upon a fear of the unknown. I say this not to criticize this fear, but as a reminder of why documents like the ODR Handbook become even more important. This is because they provide valuable information which makes the transition into the unknown easier. It is in moments like this when it is important to remember that change is nature and we should not avoid it for too long, lest we, particularly in the judiciary, get left behind. The time for a change to ODR has come and it is here to stay. Let me conclude by referring to 4 concepts of ODR and of this handbook, which I think it is central to emphasize. First, the need to decentralize, what we call in Hindi as Vikendrikaran. The second, I believe, is the need to diversify, what we call in Hindi as Vividhata. The third, the need to democratize the process of delivering justice as a service, what we would call in Hindi as Prajatantrikaran. And finally, the need to disentangle justice from all its complexities, or what we would in very simple terms call Suljhao. So it is in these 4 concepts, namely decentralization, diversification, disentanglement, and democratization of the entire justice delivery mechanism, that the strength of ODR is really founded. Thank you very much for inviting me.
Thank you so much, Justice Chandrachud and Mr. Kant. Both your remarks and notes give the encouragement the field needs at this historical moment to move forward. And it wouldn't be possible without your own thought leadership on this and commitment to encouraging all actors to adopt it. I would love to direct everybody who's listening in to where you can look into the handbook a bit more, you can go to www.disputeresolution.online and download your own copy of the Odr Handbook. I just wanted to quickly ask if Mr. Kant and Justice Chandrachud happen to have a hard copy in their hands. Do you happen to have a hard copy nearby?
Yes.
If yes, may I request you to please, this is the challenge of not having a physical event. May I request you to please put it up? Thank you so much. Thank you. This is, I think, the closest we get to having an actual launch of the book. Thank you again so much for your comments and remarks. I would now like to invite Purnima Sampath, who's the Vice President at Tata Sons, who's been a huge proponent of the in-house ODR for enterprises, to share her thoughts briefly. Over to you, Purnima.
Thanks, Supriya. Am I audible?
You are.
All right, great, thanks. Thank you, Agami, and thank you to all the organizations that have worked hard the past 18 months to put this together. You know, I think, I know I have 2 to 3 minutes and I'll stick to that timeline, Supriya. Time is a scarce resource, a very scarce resource for all of us. And I think we need to calibrate how we run businesses, how we run judicial processes, keeping in mind the value of time. And when you and Sachin Malhan raised the issue of ODR about, I think, almost 2 years ago, on parallel tracks, we were exploring this within the Tata Group. We broke up our cases into consumer cases involving the government, very high stakes litigation. Government cases will continue, high stakes litigation will continue as is for some time to come. But I was firmly of the view that a lot of consumer disputes involving smaller claims involving our products and services cannot be congesting the courts. The courts have far more important issues to deal with. And I've been working with other conglomerates in India to see if we could use the ODR model internally. So for instance, we have ombudspersons, can I have retired judges, can we have technical experts as a panel, and each time there is a dispute, people log in, they file the claim, they upload invoices, and an independent panel that, I guess, you know, how one pays for that is a separate issue to avoid conflict of interest. But can that panel use the ODR systems to resolve, disputes as much as possible? So I'm keen over the next few months to work through the FICCI, through the CII, tie up with my counterparts at the Aditya Birla Group, with different Tata companies, with the Mahindras and with the Bhartis. And I think if 5 business conglomerates really push for it, hopefully by the end of the year, the needle will move. So I'm hopeful, and I'm so glad, huge thanks to all of you for pushing this through. Fantastic.
Thank you, Purnima. We really look forward to seeing how that pans out, and do keep us and the rest of the ecosystem interested in this space on how that progresses. Sumit, I'd like to now invite you, for everybody who's listening in. Sumit Gupta is the Director and Head of Collections at Udaan. In March 2021, Udaan participated in its first of ever kind online conciliation camp organized by an ODR service provider, and he'll briefly share Udaan's experience and talking about the handbook. Over to you, Sumit.
Thank you, Supriya. Can you hear me?
Yes, we can.
Okay. Good afternoon, Honorable Justice Chandrachud, Mr. Amitabh Kant, and fellow panelists and audience. We are at Udaan. First of all, want to thank you, and we feel privileged to participate at this event and excited to adopt the ODR in resolving dispute. Just to give you a brief, Udaan is transforming the way trade is done in India by leveraging technology. Udaan is helping and empowering small businesses by offering them solutions such as access to national market, supply chain, logistics, as well as trade credit. We are currently present in about 900 cities, and our aim is to make ease of doing business possible for small and medium enterprises through the power of internet. So when the pandemic gripped us last year, it brought a lot of new challenges to the financial industry. Key dispute resolution mechanisms like Lok Adalat, which were very popular, were not available. And world was moving to a new normal. During this period, we invested our efforts on using technology for faster resolution of disputes, ODR being the prominent one. So as the SMEs are recovering from pandemic, we did not intend to choke their bandwidth to visit courts or Lok Adalat, and therefore wanted to adapt the digital means of conducting proceeding. We conducted the first online conciliation camp in the country, or rather one of the first online conciliation camp through Samas Sujhav Manch. Customer or our borrowers were able to access their disputes, share their views, and talk to Udaan representatives with the confidence of a presence of a neutral conciliator. This could be done through the ease of the handphone without requiring them to stepping out their house and with no expense at their end. We were, just to share some numbers, we were successful in resolving significant number of disputes in 30 days, and average resolution taking only 126 minutes, which is about 2 hours. Now, as the financial ecosystem adopt technology for onboarding, like e-signing, e-stamping, e-documentation, I think the ODR, to our mind and our opinion, is a progressive thinking. It helps build a more sustainable legal ecosystem. We are able to meet our promises to our customer that the complete process is now digitized, from the onboarding till the end of resolution on each and every dispute at their end. To conclude, and quickly, the launch of this ODR handbook shall be the step in the right direction, which Udaan is delighted to have participated. We look forward to enterprising opportunity and building capabilities for our learning in Udaan ODR space and creating value for our customers, especially SMBs and ecosystem impacting SMBs. Thank you. Thank you, Supriya. Back to you.
Thank you, Sumit. I just want to thank everybody again, for sharing your own experiences and leadership around ODR. This is, I think, like just to quote Justice Chandrachud again, as we step into the unknown, we really, really hope this tool enables each of us to sort of take that step, be able to adopt ODR. We'd invite every actor here, businesses, other organizations, actors to see what the role they can play in advancing this movement is. Please do download the document, the ODR handbook from www.onlinedisputeresolution. And we would really, disputeresolution.online, sorry to clarify. And yes, with that, we hope this becomes, again, to quote, the more appropriate dispute resolution and the norm in the coming years to come. Thank you all. Thank you again, Mr. Kant. Thank you, Justice Chandrachud, Sumit, and Purnima for sharing your thoughts. Look forward to working with all of you on this.
Thank you, Justice Chandrachud. Thank you so much.
Very much. Thank you.
Thank you.
Thank you, everyone.
Thank you, everyone.
Super document.